The consent of the original petitioners and the monitoring committee merit due consideration of this court. Much good work has been done in the state of Karnataka because of the action initiated by the original petitioner and the subsequent judicial intervention by this court. In fact, it is this progress made steadily over the past decade that weighed with this court to even consider the relief regarding raising of the ceiling limit sought by the present applicant. The concerns raised by the original petitioner of possible over-excavation and its adverse impact on intergenerational equity must be balanced against the concern of the other parties, as the principles of sustainable development also comes into play. This court has generally accepted the recommendations of the CEC when it comes to the ceiling limit. In the present case, the CEC has recommended a complete relaxation of the ceiling limit, but we are not inclined to allow the same in toto. Rather, the situation merits a caution approach, keeping in view of the concern raised and to ensure that any changes in the situation with respect to the mining activity in the state of Karnataka is brought about gradually. We are of the opinion that the ceiling, a limit of iron ore mining may be raised from 28 metric tons to 35 MMT for district Bellary and 7 MMT to 15 MMT to Chitradurga and Tumkur districts collectively. Conservation of ecology and the environment must go hand in hand with the spirit of economic development, and fine balance between two goals is what is sought to be achieved even now. IAS 83141 72931 as far as IA 10973 of 2008 is concerned, the same relates to direction to the CEC and the monitoring committee regarding deciding application for enhancement of MPAP in terms of the earlier orders of this court. The same may be considered by the court on the next date of hearing.
Freebies is 15. Please.
1503. Sure, this is like freebies map. Question raised in the present set of petitions relates to promises made by political parties for the distribution of free goods or freebies as a part of their election manifesto or during election speeches. The main contentions of the petition is that such pre-election promises, which have a large-scale impact on the economy of the state, cannot be permitted. The petition submits that such pre-election promises are being made by political parties without any assessment of the financial implication on the state is nothing but an attempt to attract the vote bank. This goes against the spirit of reasonable electioneering and is adversely affecting free and fair elections. This severely affects the level playing field between the different political parties. The taxpayers is ultimately being misused for political parties, candidates to gain or retain power. In this batch of petitions, there are two sets of petitions. The first batch relates to pre-election freebies, which may influence voters at the time of elections. The second set of petitions challenging the grant of benefits by the government, which do not relate to any welfare measure or development activity, but rather are a ploy to capture vote banks. The land solicitor general responded, and thereafter the election commission, additionally some other implicit respondents and all that. And ultimately, freebies may create a situation where the state government cannot provide basic amenities due to lack of funds, and the state is pushed towards imminent bankruptcy. In the same breath, we could remember that such freebies are extended utilizing taxpayers' money only for increasing the popularity of the party and electoral prospects. We have considered the issues raised in this batch of petitions from various angles, as well as the stands taken by the Union of India, Election Commission of India, and some political parties who have file intervention applications before us. There can be no denying the fact that an electoral democracy such as us, the true power ultimately lies with the electorate. It is the electorate that decides which party or candidate comes to power and also judges the performance of the said party or candidate at the end of the legislative terms during the next round of the elections. It is also necessary to highlight herein the point raised by some of the interveners that all promises cannot be equated with freebies as they related to welfare schemes or for the public good. Not only are these issues a part of the directive principles of the state policy, but are also responsibility of the welfare state. At the same time, the worry raised by the petitioners herein that under the guise of electoral promises, physical responsibilities being dispensed with must also be considered. This court generally states its hand when confronted with issues relating to policy or physical matters concerning the state, as the same falls outside the ambit of the court's jurisdiction. Initially, with the objective of initiating a discussion about the issues highlighted, we are of the opinion that it might be appropriate to constitute an expert body for suggestions from the parties before us regarding the possible composition of such a body. Additionally, during the course of the last hearing, we had suggested the Union of India that all party meeting can be called to consider this issue. Ultimately, it appears us that the issues raised by the parties require an extensive hearing before any consent orders can be passed. Certain preliminary issues that may be need to be deliberated upon and decided in the present set of petitions as follows. What is the scope of judicial intervention with respect to the release sought in the present batch of petitions? Whether any enforceable order can be passed by this court in this state petition? Whether the appointment of commission/expert body by the court would serve any purpose in this matter. Additionally, there should be the scope and composition and powers of the said body. Apart from the above preliminary questions, many of the parties before us also submitted the judgment of this court in Subramania Balaji requires reconsideration. Subramania Balaji, People's Act. The court in that case held that such promises do not fall within the ambit of corrupt practices as specified under Section 123 of the Representation of the People's Act, and issued direction to the Election Commission of India regarding framing of certain guidelines in the absence of any legislative enactment covering the field. Looking at the complexity of the issues involved and the prayer to overrule the judgment rendered by two-judge bench of this court, Subramania Balaji, we direct listing of the set of the petition before the three-judge bench after obtaining the order from the Honorable Chief Justice. List of the...
After 2 weeks, subject to my Lord's pleasure.
4 weeks?
4 weeks. Grateful to you, Lord.
Very grateful, Your Honor.
Thank you, Mr. Ashwini Kumar, bringing the issues in the program.
We will miss you, Lord.
Ashwini Kumar, P. ML Sharma. Sharma is not there?
1504. 1504.
Yes. For the aforesaid reasons, we concur with the findings returned in the impugned judgment, which is upheld. The appellant state government is directed to take necessary steps to process the allotment of the subject land in favor of the respondent company within 4 weeks from today. The respondent company shall file a fresh undertaking with the state government within the same timeline as was